Step number 5. Taxes, debts, and claims is something that is a concern of successor trustees because they want to make sure they don't have the personal liability of these assets. Let's first talk a little bit about estate taxes, and I can give you the good news, which is currently the law is very favorable to taxpayers. The federal exemption for this year is $12.06 million, and the Hawaii state exemption is $5.49 million. Now, the critical exemption is when I die. The exemption might be higher or it might be lower. It really will depend upon what the law is at that time. So that's where it is important to, seek the advice and the information, because if the estate is required to file an estate tax return, it has to be done within 9 months of date of death. You can file for an extension, but just like income taxes, even if you file for extension, you got to pay. If you don't pay the anticipated income taxes, then there's interest and penalties. So why I wanted to really focus on that one is that is a time-sensitive one. Even though it seems like it might be very unlikely, it is very time sensitive. And so situations where people just kind of put it aside for a long time because they're going through the emotional upheaval of a death, it could be that, it has some detrimental effects. There's also, of course, my final income tax return. So Jonathan, as my successor trustee, would also have the responsibility of filing that. The beauty of it is the expenses are paid from my estate. That's why we tell people who are nominated as the successor trustee, get good, competent advisors, because that will help protect you, and that will be paid for by the assets that you are managing. There's also what is called a fiduciary income tax return. A lot of my clients who had done their estate plan pre-2005, they might have created 2 separate trusts if there were a couple. 1, the exemption amount was much lower, and 2, we did not have what is called the portability election that allows for the use of the deceased spouse's exemption. There was a good reason why 2 trusts was established. But what that meant is when one spouse died, that spouse's trust continued in general until the survivor died. So if one spouse died, say this year, and the survivor, might live for another 10 years, during this period, all of the income that was being earned by the deceased spouse's trust, maybe there were some rental property in there, half of the rental income is supposed to be filed under that fiduciary income tax return for that trust. I know that that's a difficult concept, but I wanted to mention it to you because a lot of people don't realize that they do need to speak to an accountant and consider that it may need a filing both for the deceased spouse's trust as well as their own personal income tax return. Because personal liability is always an issue, we tell people, don't distribute until you know that you've taken care of all of the debts. That's why the sooner the trustee understands that they have to take these steps, the sooner we can get to step number 7, which is the distribution. It doesn't mean that you can never make partial distributions. It's just that the trustee has to understand that if I am going to be distributing, I got to make sure I do have enough to pay for those claims. So step number 6, accounting. This is very important. Whenever somebody comes in and tells me, family member has died, I'm the nominated successor trustee, I tell them, are you willing to serve? And they say, yeah, I think so. I mean, what do I need to do? And I go through this and I emphasize, you have to keep good records. If you don't think you can keep good records, hire someone to keep the records for you. Keep all the receipts of all that is being spent. You got to know what's the income that are coming in, because ultimately the other beneficiaries are going to be entitled to get this information. And if they question something and you don't have the documentation, that's what can create the conflict again. And that's what we're trying to avoid. So if you have the information from the beginning, it makes the process so much easier. Our goal here is for you to know the steps so that hopefully things go right. Okay, finally, distribution to the beneficiaries is after everything else is done. It can be very simple at times. Maybe the assets consisted of a bank account. And so now all of the expenses has been paid. Maybe there's some unknown expenses, in which case the trustee and the attorney should talk about doing what's called a reasonable reserve, so that it's not like the trustee has to go back to the beneficiaries to get money to pay for expenses that might be a little bit over. But the goal is to try to get the distributions to the beneficiaries appropriately quick as possible. Because like I said, that's what tends to minimize the conflict. So if it's an outright distribution, then write the check, right? Very simple. But this is another piece to be very, very careful about. The trustee needs to make sure, does the trust say certain things and restrictions on the distribution? Our goal with this presentation is so that the trustee knows the 7 steps and can act appropriately to minimize conflict. In the event that there is a dispute and a contest, the trustee needs to understand that if the trustee is acting properly, he or she can get the expenses of the defense paid by the trust. So that's another reason why trustees really should, seek good counsel. What I want to do is to just repeat again the 7 steps. The successor trustee needs to get authorized to act as successor trustee. Notice has to be given to certain people. The assets need to be marshaled. What that means is collected and accounted for. Then those assets, during what is referred to as the period of administration, needs to be managed prudently. If there's taxes and other expenses, those things need to be settled. The trustee should provide a report, which we call an accounting, to the beneficiaries. And then finally, the distribution to the beneficiaries. So with that, I'm hoping that you have a better understanding of what happens upon the death of a living trust. The information that was presented today is information, not legal advice, because you may have certain particular circumstances that might be different and require different considerations. So I would encourage you, if you do, to seek competent counsel.